How to read a Supreme Court case. Sandy? Steven? You got that one? Okay. They may appear daunting at first, but once you get into them, they're the most fascinating way to explore the laws of our country. So the Supreme Court is a kind of court called an appellate court, which means that it hears appeals. Easy enough. Always heard that. Never knew what it meant. And if you're curious about how a case gets to the U.S. Supreme Court, we actually covered that in our episode 27, How a Case Gets to the Supreme Court. The U.S. is split into 94 federal judicial districts, and those are divvied up between 12 regional circuits, not entirely unlike college basketball. So if you lose a case, you can appeal it up to your circuit's Court of Appeals, which consists of 3 judges who decide whether or not that ruling was fair. And if you disagree with their opinion, you can file for what's called a writ of certiorari. 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 Whoa. So the Supreme Court gets about 8,000 filings for writs of certiorari a year, and they end up hearing about, if at least 4 of the 9 justices on the Supreme Court, or 8, things are getting wacky, vote and say we should hear this case, then they grant the writ of certiorari. So, now that you know how they get there, which I said I wouldn't do, how to read a Supreme Court case. The first question is where to read them. I'm just going to say the one place I read them, and you can go somewhere else if you like. I go to OYEZ, that's O-Y-E-Z. It's a nonprofit site from Cornell, the Cornell Law School, and it is an amazing repository of Supreme Court cases. OYEZ is part of the chant uttered at the daily meeting of the Supreme Court, and it comes from the French verb ouvrir, which means to listen, and OYEZ is the sort of command, the VU form. So it's like basically, listen up, hear ye, you know, listen, listen, listen. We're about to do some judging. We're about to do some justice. For the purposes of this video, I'll be referencing the wonderful, fascinating 1989 court case, Texas v. Johnson, where it was decided whether or not the burning of an American flag is protected speech. So each Supreme Court case consists of these things. A name. Oh, what's in a name? A syllabus. An opinion. And a disposition. Sometimes also there is a concurring or dissenting opinion. First up, the name. Unlike most court cases, it's not the plaintiff and the defendant. It is the petitioner and the respondent in a Supreme Court case. The petitioner is the person who lost the previous case, so they're appealing to have their case overturned, and the respondent is the person who won the previous case. So in Texas v. Johnson, Texas lost the previous case, and they ain't happy with it, and Johnson won. Johnson messed with Old Glory, and he messed with Texas. Don't do it. Did you know that was a litter campaign? Don't mess with Texas was from a litter. It was a litter campaign. Anti-littering campaign. So the petitioner's name always comes first. Good to know. Little news you can use. The syllabus. The syllabus is written by somebody who works for the court, and it's just a summary of the facts of the case and how the court decides to vote. It's a great place to start. Always read the syllabus first. OYEZ does something even cooler. They actually lay out the very, very short paragraph, the facts of the case, and a summary of the case. I read that before the syllabus, so I know what I'm getting into. Part 3 is the greatest part. The opinion. The opinion is where the court tells you how it's going to vote and why they voted that way. They cite the legal reasoning for their vote. They cite precedent from previous cases. They cite the argument that happened beforehand when the case was argued. They have a good long think about it. So when the court decides how it's going to vote, let's say Texas v. Johnson, which was a 5-4 vote, 5-4 did. The 5 people who were in the majority, which is how the vote was going to go, they met together and they decided who's going to write the opinion. And they vote for something for one of the justices and the majority to write the opinion. The 4 who vote against it write what's called, if they want, the dissent. And the dissent is my favorite part, because people seem to be very passionate in their dissents of cases. Sometimes the opinions also have little twists of personal stuff in it. For example, in the case of Texas v. Johnson, there's a poem about the beauty of the flag in the dissent. How great is that? a poem. So then there's the disposition, which is just how the court votes. It's either affirm, reverse, or remand. Affirm means they stand with the decision of the previous lower court. Reverse is they flip the previous decision of the court. And then remand is send it back to the lower courts for a retrial. Get that case out of here. Get out of here, case. Get out of here, Texas v. Johnson. Concurring and dissenting opinions are usually a lot shorter and they're more fun. And concurring opinions are usually, I agree with the majority, but I have a different legal reasoning for that agreement. And dissenting is, I disagree and here's why. The arguments by the lawyers, actually I think they're called advocates in the Supreme Court, have been recorded and made public. So anybody can download and listen to the arguments of these lawyers before the Supreme Court. And they're fascinating. Sometimes they're really funny. Sometimes they're really impassioned. Texas v. Johnson, and the advocate for Johnson, is a guy named William Kunstler. And he is hilarious. He has Thurgood Marshall even laughing at certain points.
You get into vagueness.
Are you going to get back to the case?
Yes, I'm getting back to the case. Seems to me we had this 3 weeks ago.
You can see who's saying what. You can see how the people voted. You have a wonderful scrolling transcript to see who's talking all the time, which is really useful. And after a while, these are not just dry historical characters, but they're almost like how we think of our presidents. So you too can dive in. A word of advice: don't read any cases before 1920. It could be really hard. Marbury versus Madison. Dear God. God, I hope we can get someone to explain McCullough v. Maryland. I've read it like 10. I don't understand it. I don't get it. Smarter people will tell you to look for facts and legal reasoning, which I agree with. But I think also try to find the fun in these things, whatever you can. Wherever you can. Find it. Do you have a favorite Supreme Court case? Let me know in the comments section. It's my favorite Supreme song. I guess it's that one. The Happening. Anyways, let's see how this works out. Keep being civil. Have a good one.